made the Justice Court. The Honorable Cecil Ash presiding. Para Espanol.
Please hold while I try that extension.
North Mesa, this is Lynn.
Hi, Lynn. Can I speak to Stacy, please?
Sure. Can I tell her who's calling?
Madison.
Okay. She is busy with other customers at the counter, so if you can hang on just a minute.
Sure.
Thanks.
Well, we are actually on hold. We have a hearing that we're supposed to be meeting with Cecil Ash and the district attorney.
Okay. All right, then. I'll remind her that you're holding.
Okay.
Should you actually be talking to the county attorney then?
Yeah, we have a pretrial hearing. This is the arraignment hearing.
Defendant's name?
Madison.
He's not in his office either. Well, you're still on hold. I didn't want you to think we're not, that we don't know you're there. So bear with us, please.
Okay.
Thank you, sir.
Hello?
Yes.
Hello?
Hello. Hello, can you hear me?
Yes, who do I have on the line? Madison. Okay, Madison, this is Judge Jones. And here in the North Mesa Justice Court.
Judge who?
Jones.
Okay, I believe our case was under Judge Cecil Ash.
Cecil Ash is at a bench meeting today. I'm the pro tem today.
Okay.
I was the judge here until the end of the year, and now I'm back just to pro tem.
Okay.
All right, and you are, sir?
My name is Adam. I'm supporting and assisting Madison.
Are you an attorney?
No, I'm not.
Okay, I need to just have Madison get on the line then, and we'll speak directly with her.
I understand.
All right, thank you. I'm going to, I reviewed the case, and so, Madison, we have you on the line, correct?
Yes, we do.
All right, and we also have here from the state. All right, so we have county attorneys here, and Madison. The purpose of this argument is to address a motion that you have. What are you seeking?
I'm here by restricted appearance in the matter of myself, Madison, to challenge the jurisdiction only. I'm not here to plead or to testify until the plaintiff has provided the court with a verified complaint and evidence of jurisdiction.
Okay. So you're waiting for the state to provide the complaint and evidence of jurisdiction.
Yes. I have a pending motion, and I would like to go through that if there's no opposition to it.
Well, go through your motion, and then we will allow state to discuss that. So please review your motion, what you would like, what you're seeking.
Okay. So there are 6 different points to the motion, and the first point is that the plaintiff lacks standing. The second is that there's no corpus delicti. The third is that the lack of a jurisdiction. The fourth is the complaint is unfit for adjudication. The fifth is that there's no evidence of presence within state and laws applicable. And the sixth is that the court's jurisdiction is not enlarged by police authority. Can the plaintiff speak to each of those points so I can understand them?
Absolutely. Ms. Michaud, why don't you come forward so that she can hear you better on the phone?
Sure, Your Honor. And of course, the state objects to every aspect of the defendant's motion. First of all, the state would ask that the motion be denied because it does not comport with the rules of criminal procedure as far as proper filing or filing format is concerned. Second, I suppose I'll address each of the points individually. The state of Arizona, of course, has standing over all criminal matters committed in the state of Arizona, particularly the Maricopa County Attorney's Office, does have standing to prosecute criminal cases in Maricopa County. Specifically, there is jurisdiction over this matter for this court and for this prosecuting office. The defendant was spotted by Maricopa County Sheriff's Office Deputy, or excuse me, I'm sorry, this is a DPS case. This is by DPS Officer Frost, violating ARS 20-701.02A3, that is an excessive speed violation, in Maricopa County in the jurisdiction of this court, very specifically on SR 87 at milepost 195, which is in the North Mesa jurisdiction. On those assertions alone, it's clear that the state has standing and that our office has standing to bring this case in this court. The defendant, I suppose that's the defendant's first and third argument, but there's no standing and there's no jurisdiction. Corpus delicti requires that there be evidence that an offense occurred and evidence to support a rational inference that the defendant is the one who committed that offense. It's clear that there is both. The defendant was spotted going 90 miles per hour in a 65 miles per hour zone by Deputy Frost. It's clear that a crime has occurred. We have evidence. In fact, we have a witness. The witness to that crime is, of course, Officer Frost with DPS. Fourth, I believe that this is her fourth point. She argues that the complaint is unfit for adjudication because there's no adversarial issue here. Clearly, I'm not sure what the basis of that argument is. Clearly, there's an adversarial issue or a conflict of controversy because the state is alleging that the defendant violated a criminal statute. And point 5, I believe, Your Honor, is something that the court should pay particular attention to because that is the bulk of the defendant's argument and the bulk of why this sort of motion is being filed. Your Honor, the defendant is arguing that the state of Arizona is merely a geographic boundary and that it does not have jurisdiction over her. This is a common sort of motion that we see as prosecutors in Maricopa County. It is a fantasy. It is completely beyond any imagination. It tends to be the basis for many motions such as these. I think it's clear. The defendant was spotted in Arizona, in Maricopa County, in the jurisdiction of this court at milepost 195 on SR 87. To argue that she's not in the jurisdiction of Arizona or that she's not beholden to the laws of Arizona is frankly a flight of fancy. It's something that she's imagining, and that's not correct. To grant additional points, the court's jurisdiction is not enlarged by police authority. No one's asserting that it is enlarged merely by police authority. It's clear that the court's jurisdiction is over the North Mesa Justice Precinct, which is where this offense is alleged to have taken place. I'm not sure how to proceed beyond that. This is an unusual motion, and I'm not really sure exactly what the scope of the oral argument was supposed to be. I've addressed each of the points. The extent I feel that they need to be addressed if the court has any additional questions, of course, I'd be happy to.
All right. Thank you, Mr. Michaud. Ms. Morgan, is there anything else you would like to add?
For filing, I would like to know why it's incorrect. It was filed in triplicate to officer, the court, and the DA.
Okay, my question to you is, you submitted a motion to the court, and you stated your reasons for your motion of what you would like to have the court do to address the charge against you. And this county attorney has just addressed each point. I'm asking you, is there anything further that you would like to add before I make a ruling on the motion?
Okay, I would just like to add that there's no evidence on the verified complaint.
to verify the complaint, did you receive a copy of the citation at the time that you were pulled over on State Route 87 in Arizona?
I'm sorry, could you say that again?
At the time that you were pulled over on State Route 87, were you given a copy of the citation from the officer?
Allegedly, yes.
Allegedly. He handed you a copy of the citation, the charge that was made.
Yes, it's a citation not verified.
Verified how? You were stopped by a police officer. You were cited for violating a state statute. How is that not verified?
Can the prosecuting attorney certify the charges?
Sounds to me like what you're asking for is you want to have a trial to challenge the officer pulling you over.
No, not a trial. I'm not an attorney, so I'm just trying to understand everything that is the nature and the cause of the charges in the proceedings going forward. So, not being a lawyer, I'm not familiar with everything, so I'm asking a lot of questions so I can just fully understand what's happening.
Your Honor, if I may, it's clear that the defendant is not responding to the quick questions, and furthermore that the defendant is using this motion or this hearing in order to ask the state to prove its case. I'd ask at this point that the court just deny the defendant's motion.
All that you were stating here is a challenge to the authority of the state of Arizona and the citation that was issued. So if you want to have that challenge, this hearing now is not going to be a determination of guilt or innocence. And if you want to proceed in saying that you are not responsible for what has taken place, then we will have a pretrial conference and we will proceed as necessary to address the charges. I am going to deny the motion that you have presented, each count. I do not feel that they hold sufficient evidence to deny the fact that you did indeed travel through the state of Arizona in this court's jurisdiction. You were cited by an officer who stated that he clocked you on radar, and that's all specified in the citation. Everything is clearly marked, indicated of what the charge is, and so what needs to happen is if you feel you want to plead not guilty, then we will set a pretrial conference date. Is that understood?
Well, firstly, Your Honor, I object because it's not a verified complaint, and I can't say until I understand. So I have a few more questions. Am I presumed innocent of this alleged crime?
You are always presumed innocent until such time as it is proven whether you admit guilt or whether it is proven whether you are guilty or not guilty in a court proceeding. Now, as with every citation that takes place, you have every right to prove your innocence, and that is what we are going to provide for you. So at this point, again, the motions that you presented are denied. And if you wish to not plead guilty or responsible for the driving offense, we will proceed with a pretrial conference. That's standard procedure. When you try to talk about a verified complaint, it is verified as is standard procedure, as all citations are. There's nothing unusual about what took place. What's unusual is the proceeding we're having right now. And so I ask again, Are you wanting to proceed with a guilty plea or a not guilty plea?
Well, I don't know if I understand everything, and I can't say yet, Your Honor. I need to understand a little bit more. If you don't mind, I'd like to ask a few more questions.
Okay. Ms. Morgan?
Uh-huh.
The bottom line is it's a valid complaint, and I'm asking you if you do not believe that you are guilty or responsible of the charge, then we will set it for a pretrial conference where you can address everything that you want to with the county attorneys, and if it ends up going to a trial, we can certainly do a trial. But yes, always you are presumed innocent until such time as the trial comes to a conclusion or the case comes to a conclusion. I do not believe any more questions that you are going to ask are going to be sufficient enough to change the procedure of what will take place. Do the questions that you have validation in that you're trying to understand how the court process works? What is it you're seeking?
I'm just trying to understand the nature and the cause of the charges against me. It's that I need to know that the complaint is verified on the face of the ticket.
All right, then if that's what the verification you want, this is set for a pre-trial date where you can come, and if you wish to confront the officer to validate why he gave you the citation, that is your right. This hearing is concluded. We will set a pre-trial conference date. Stay on the line, and staff will get with you to set that date.
Your Honor, I have not pled.
Well, I have given you that option, and you're not taking a guilty plea, and you are going to answer me now, guilty or not guilty. That is your option of answers, or no contest. But you need to enter a plea now.
Well, I can't, Your Honor, I can't enter a plea because I need to understand.
Then if you're not going to plead guilty, I will enter a plea of not guilty so that you can address this with the county attorney. We are not going to prolong this time now trying to beat around the bush of whether or not you received the citation. You do not wish to plead guilty at this time, so my only option is to enter a plea of not guilty so that we can proceed to the pretrial conference. Do you wish to plead guilty instead?
Your Honor, I object. On whose behalf are you entering the plea?
What?
On whose behalf are you entering the plea? Are you representing me right now?
Ma'am, I need you to understand very clearly that you are challenging the court and the court's authority. You have an option now to go ahead and enter a plea. If you do not wish to enter a plea of guilty, then we will enter a plea of not guilty. You are not to make a mockery of this court. Do you understand?
I understand, Your Honor. I know that once jurisdiction is challenged, it must be proven, and I haven't. And if I'm presumed innocent of every element of this crime, jurisdiction is one of them.
That's correct, and that's something that will prove at trial.
That is always addressed at trial. If you wish to take this to trial, it is the responsibility of the plaintiff, the state, to prove all the elements, jurisdiction being one of them. So if you are not willing to admit to the guilt, then By default, you are pleading not guilty. We will proceed with proceedings as necessary to determine your guilt or innocence. And I can't say it any clearer. We're not going to prolong this with technicality of trying to challenge the court's authority. The citation was issued, and you have every opportunity to challenge what that citing officer said to you and what citation, all that he put on that citation, that you have in your possession. So I will remind you, you have an option right now if you want to plead guilty. Otherwise, you will have a plea of not guilty and proceed with court processes. Do you understand?
No. Thank you for your patience, Your Honor. Where there is an absence of jurisdiction, all administrative and judicial proceedings are a nullity and confer no right, offer no protection and afford no justification, and may be rejected upon collateral attack, which is a Supreme Court ruling. Are you bound by the rulings of the Supreme Court, Your Honor?
Okay.
The sites that she gave in her motion are irrelevant to this matter. They're mostly civil cases, Friends Act, and that, so it is irrelevant to this proceeding.
Okay. Ms. Morgan, all the questions that you are asking at this time are things that are addressed in the normal course of court proceedings. On the arraignment, on initial appearance and arraignment, what happens is, very simply, there's an allegation made and you have the right to deny or admit. And since it's apparent that you are not admitting guilt or responsibility, that you wish to proceed through the court process to challenge those things. And so, I will make it very clear again, I'm not taking any more questions. If you do not wish to plead guilty, then you are pleading not guilty. It is set for a pretrial conference, and you will have every opportunity to address every element of the charges against you. Do you understand that?
I understand, Your Honor, that it's my Sixth Amendment right to understand the charges that are against me.
It is your Sixth Amendment right. You have definitely the right. So I will review with you one more time what it is. On January the 1st of 2013, on State Route 87, milepost 195, which is geographically in this court's jurisdiction, and we handle these cases all the time, it is definitely in this court's jurisdiction. You were cited for speed exceeding 85 miles an hour, and it was by a DPS officer, Mr. Frost, and that measurement was taken with radar equipment. You were traveling south. That is all record. It's on the citation. It's legitimate. It's a valid citation. The only option you have at this point is plead guilty or not guilty. That is the charge. You understand that charge, and this is your option to proceed. Do you understand clearly?
No, I don't understand.
Well, you do understand, and you have people coaching you, and you're trying to make technical challenges before you ever come before the court. You will be set for a pretrial conference. This hearing is over. Thank you very much.
I object.
Have a good day, and staff will give you the date and time of that hearing. Thank you.
Is anyone on the line still?